Hi, welcome to today's presentation. I'm Dr. Chris Rapoff, and today we're going to cover a topic that I'm afraid most of us will become familiar with. That is, if you already have it in your role as a qualified medical evaluator. Today we're going to discuss independent bill review, IBR for short, and the disputed payment appeal process. This is pretty involved, so this should be an interesting topic for you if you're not familiar with this. This is the first installment of a three-part series where we will be discussing the IBR process. Today we will begin with an understanding of why we need the IBR and an introduction to the independent bill review process. Well, first let's examine how and potentially why we even got to this point of requiring an independent bill review. Let's start from the beginning and we can go through this process together. First, we receive a call from one of the parties. Then they're requesting a QME examination. We oblige their request and we provide them with a date usually within the 60-day window. And these time frames that are established that we are to be compelled to follow are actually found in Section 38 of Title 8 of the California Code of Regulations. So second, we will examine the applicant and then we'll provide the parties with a very well-written, well-thought-out report within the 30-day time frame that we've been allotted. Also, we have to accompany this with the HCFA billing form with our charges for the examination procedure, and it's outlined on the form. And finally, third, well, now we just sit back and checks in the mail, right? We wait for the report checks to come pouring in. Well, according to that same section 38, they're required to pay for that report within 60 days of receipt of the report. I don't know about you, but it's about a 50-50 proposition for that to happen in my office. Well, that sounds like a very simple process that I just explained, but that pretty much is where the simplicity of the QME report writing, billing, payment process ends. You'll probably, if you haven't already, you'll be getting some excuses when you are asking where is my check for a report that is now 60, 70, 80, 90 days past the report writing date. And you're going to get some claims administrators saying the most common one is, well, I didn't get the report. Did you send it? Well, we are required to do it within 30 days, and if not, there is retribution. However, if they don't receive it within that time frame, they don't really need to even address this unless you call them and ask them, where's the money? Another excuse would be, I received the report, but it doesn't appear in the system. I do remember receiving it. I acknowledged it. I stamped the date and it went into the process, but it is no longer in the system. Another example, I didn't specifically authorize a QME exam in the first place. So I'm not paying, I'm not responsible. I'm in the process of this currently right now with one of the claims administrators, as the claims administrator states that they did not authorize the defense to request the QME examination or receipt of the report. So they are balking at this, and now we are beginning an IBR process very quickly. In addition, this report just happened to have an extra 1,495 pages of medical records for me to review. So as you see, this is a pretty substantial report that they are now denying payment on. We'll see what happens. Another example that they give us, well, you didn't meet the 30-day window for my receipt of the report, so I am not legally bound to pay you, or I don't have to comply. It's very interesting how we have 30 days, and on 31 days, have they not received the report, they can deny payment. Yet the check was in the mail, we were told, and then we find out when we call that, oh, I'm sorry, we didn't receive the report. Can you resend it? It's just a two-way standard here that is pretty irritating. And finally, another one, not actually the last one, but you didn't follow the new MLFS charges for your report. If you recall, in April 1st of 2021, the medical legal fee schedule changed. Some say for the better and some say for the worse. Those of us who did ML 104 examinations and wrote those reports, we're taking a substantial pay cut because, as you're well aware, the body parts were not whittled down with the payment process. As a matter of fact, the attorneys seem to be just throwing everything at the wall and hoping that we will add body parts just for the fact of there were so many. So that's something to take in consideration. So what is an IBR, or an independent bill review process? Well, first of all, let me differentiate. I don't want you to have the impression that this is IBR process is only for QME remuneration or payments. This is also for any physician that has either had a denial or a reduction of their payment by even a medical professional as well for their treatments. They do have some parameters it must apply, and initial bill that's received by the claims administrator should be properly documented to apply for the IBR. And generally, this is a HCFA form and with the appropriate charges. Now, this IBR also applies to any medical service bill where the date of service is on or after January of 2013. Okay, so they have determined that approximately 10 years ago that we had a problem. So we have to create this independent bill review process to help resolve some of these issues. Now, the fee schedule that we all know well and love is established by the DWC, and that is the required fee schedule that we use as QMEs when we apply for this IBR. Okay, now I'm sure you're all well aware of the new medical legal fee schedule, the MLFS, that was instituted in April of 2021. As you recall, it could have been a reduction for many of these physicians that are writing these reports, and others feel like they got a raise. I guess it's in the eyes of the beholder. But just to review very quickly, the most common, the ML 201s, are being paid $2,015. The 202s, which would be a follow-up evaluation or a re-eval, is $1316.25, and supplementals are $650, supplemental reports. I wanted to bring down to the very last line here in this slide, and there are other modifiers that they use for AMEs and the like, but one very abused modifier by these claims administrator are the modifier 93. And the modifier 93 is when you have an interpreter that is required for the examination process. You multiply your 2015 by 1.1, and that gets you to $2,216.50. So you are getting an extra 10% by having an interpreter. This is being abused at a very, very high rate by the claims administrators, and they will just outright deny the 0.93, I'm sorry, the modifier of 93, and with no explanation. So they're requiring us to then spend our money, good money, which we'll get into the price of that in a few, to try to recover $216. Many physicians choose that is just too laborious of a task, too time consuming, and so many of them don't do that. So if you think about it, if they deny 100 cases of this modifier 93, and then only 50% of those doctors will reapply for that 0.1 add-on, so they saved 50% of that charge just by refusing or denying the payment initially. Well, how did the IBR system come about? Well, in 2013, they passed a law that reformed the workers' compensation system in California, and it's called the Senate Bill, or SB 863. This had the blessing of the then governor of the state of California, Jerry Brown, and they included a system that was an independent bill review system. So back in 2013, they realized that there were problems on the horizon and happening daily with this process of denials of payments of claims from the claims administrator. Okay, so let's see how the Department of Industrial Relations defines this IBR system. They define it as an efficient, non-judicial process for resolving medical treatment and medical legal billing disputes in which the medical provider disagrees with the amount paid by the claims administrator on a properly documented bill after a second review. This is very important. Second review is important here. So what is a second bill review? Well, they've determined that the medical provider that seeks reconsideration of a denial or an adjustment of the bill charges for a service, good, or medical legal service given to the injured worker. So a second bill review is required in order for them to process it into the IBR system. Note, though, IBRs cannot be requested until after the claims administrator issues a decision following the second review, and it's requested in a timely manner for which the medical provider disagrees. So they have to give you a second denial or a second reduction in payment until you can then apply for the IBR process. Okay, so now we have our first denial, our second denial by the claims administrator, and now you have a decision to make. What do we do next? Do we just let that go and say they won, or do we fight? If we fight, the medical provider can request an IBR, but it has to be within 30 days of the service of the second review decision. So the clock starts ticking when you receive that second denial. Upon referral by the administrative director, they have an IBR review organization, or the IBRO, will notify all the parties of the assignment, and then they'll provide them with an IBR case number or identification number. So they are into the system, and then the clock starts ticking, because then the IBRO will assign an independent bill reviewer to examine all of your documents, apply the appropriate fee schedule that you've already included, and issue a written declaration within 60 days of the assignment of the IBR. So the clock starts ticking once again. Okay, so let's follow. I mentioned that we do need to submit an application. So the provider submits an application, and you can do that via either electronic or a hard copy. And there's an application that's found on the DWC website for IBR review. So you would create this hard copy or electronic copy, and then at that time they will provide a number for you, and that will be your case number. In addition, you have to register on the Maximus Federal Services IBR tracking system. Now, this may be familiar to you as well, and some may not understand what this is, but Maximus Federal Services is the IBRO for the state of California. They provide the DWC with the data that's extracted from its proprietary software. Now, the data corresponds with the information in the final determination letters that are received by the filing parties. So your final determination letter of a denial or a reduction in payment are created. These final determination letters are sitting in a file, and Maximus Federal Services is able to access those. So if you ever want to see any of these, now of course these are anonymous, but there are copies of these final determination letters for the cases that have been decided in the current year that you are looking, and they're available from the DWC website within 30 days of their issuance. So you can actually see how the process is playing out through the Maximus Federal Services, or the IBRO. Okay, so that brings us to the end of this program today. Next time we're going to be discussing who and what is Maximus in a little more in depth. And I'm also going to be providing you some alarming statistics that basically are necessitating the process of an IBR and for the development of this whole procedure program for medical legal disputes and medical payments. So you'll be surprised, or probably not, that the statistics necessitating this IBR process has to do with bags of money. Surprise, surprise. So I just wanted to thank you for spending time with me today and trying to understand the IBR process. This is just part one of the three-part series, as I mentioned. So next week we will be tackling the second part. Thank you again. I'm Dr. Chris Rapoff, and good luck and future success as a QME. Thank you.